I'm going to take you in a little different direction, a little more in depth on political activity. And then we're going to shift gears after that short presentation and go into an area that I believe is something that is of growing concern in our office about board responsibility and corporate compliance. But specifically, we'll be focusing on the responsibility of board members. And hopefully it won't make you bored doing it. Anyway, but before we jump into the fray, many of you, there is one tax item, this is sort of tax related anyway, but there's one tax item that some of you perhaps may have already heard some information about, but I just wanted to give you just a little update. I believe last year made mention of it, the Freedom from Religion Foundation case. Anybody remember that? Okay. If I say the constitutional challenge to parsonage exclusion, does that sound familiar? Okay. The Freedom from Religion Foundation, basically an atheist organization, has sought to challenge the constitutionality of the parsonage exclusion. This case, the most recent case, filed in district court in Wisconsin several years ago, was actually their second attempt. Some might say the third attempt because they were kind of behind the scenes indirectly in another previous attempt to challenge the constitutionality of it. Now, most of us tax practitioners have for a long time been a bit concerned about the unique aspects of the parsonage exclusion being a benefit exclusively for ministers. Sounds very religious, and it sounds like it's something that a special favor that's being done for religion, which raises a constitutional question. This most recent, the second case that they, or the first case that they filed, they ultimately had to dismiss it on technical grounds. And then they refiled, presumably trying to correct some of the deficiencies in their first case, and filed a second case, and we believe that they probably did so handpicking a sympathetic judge. At least that's what it seemed like to us. The judge ruled in that case that the parsonage exclusion was unconstitutional. And needless to say, that kind of causes a lot of palpitations and consternation amongst leadership in churches, as well as many ministers that became aware of that challenge. The case was appealed by the government. The lawsuit was against the federal government, IRS and the commissioner, technically. The government appealed the case, the decision of the district court, to the Seventh Circuit Court of Appeals, which covers the kind of the northern Midwest area of the country. The Seventh Circuit just ruled on that case, and the Seventh Circuit, their ruling was fairly simple and straightforward. The good news is they dismissed the case. They ordered the decision of the district court vacated and sent an order back down that they were to dismiss that case for lack of jurisdiction. Unfortunately, they didn't actually address the constitutionality of it. They decided, many of us believe that this was probably the way they were going to decide, that they were going to decide it on this technical jurisdictional issue. Basically, it's, some might say it's a cop-out. It's like we dodged the big one and just dismissed the whole case. The technical issue was standing. Basically, in order for a person to have standing to bring a case in court, they have to have skin in the game. They have to actually have suffered a personal injury as a result of whatever it is they're challenging, so that they have skin in the game, as we say. Well, the court decided that they did not have standing. Generally speaking, taxpayers can't challenge any tax law just because they don't like them. They have to be adversely affected by them or by the application of that law. So The bottom line is the Freedom from Religion Foundation and the individuals that are in charge of it that brought the lawsuit do not have standing to bring this lawsuit because they never, the way in which they attempted to cure it is they granted themselves a housing allowance, but they never sought to claim it as exempt from taxes before the Internal Revenue Service. That was where they made a mistake. So the court said, you didn't even try. You didn't even try to see if it would work. And so you didn't give the IRS an opportunity to rule on it and to deny your attempt to claim it as an exemption. So therefore, end of case. In other words, you've got to go back and figure out a way to, do it. So the bad news is then, it's not over. The reality is they will probably come back and try again. And this time they'll probably cure it. They'll probably attempt to process their tax return, claim the exemption, IRS deny it, and then they'll have a claim. What will be interesting is if the IRS does what some might think that they could do, just ignore them. If they make no ruling on their claim of exemption, they still don't have a case because they haven't been adversely impacted by it. So IRS has a way of doing that on occasion. So we'll see. We'll just have to wait and see to see what happens. So stay tuned. Stay tuned. I hope eventually a court gets it squarely before them and rules once and for all on the issue, and that we can move forward and not have this little sword dangling by a thread over our heads. That it's going to, because this is going to dramatically, as you well know, dramatically impact how we compensate our ministers and how we would, our whole financial picture would change. Because by most estimates, this benefits pastors by several $1,000s a year. That would mean a drop in their spendable income. We would probably have to figure out a way to make that up for them, and that's going to cost the church a lot of money. Millions of dollars probably in the long run. So we hope and pray that it will turn out well eventually once we get to it. All right. Does anyone have any questions on that before I move on? About parsonage exclusions generally or that ruling? As I always do, I encourage you to interrupt me with questions. My life is a series of interruptions, and I like being interrupted most of the time. So in this context especially, I like to be interrupted because I want to make sure that what I'm saying is understood and that I'm answering questions that you might have. Because when I say something, inevitably what comes to your mind may be a question. Go ahead, raise your hand, ask the question. We can pause, we can catch up with wherever we were. That's not a problem. So interrupt me, please, when you have a question. All right. First, was there? Never mind. Question.
All right. What have you found is the best way of taking care of the parsonage allowance as far as payroll? Is it waiting till year end, doing just based on estimates, or any guidance on that?
Yeah, that's a good question, and it's a fairly frequently asked question actually, because essentially the Internal Revenue Service recognizes probably about at least 3 different ways and they don't really mandate, you got to do it this way or this way. So they will recognize and defer to the churches on how they process it. My bias would be, for accuracy purposes, that it not be based on an estimate toward year end, because it should be on actual. There's some difficulties, there's pros and cons either way. If you simply report the net amount, there's another way of doing it that we don't normally do, just reporting the net amount on the W-2. That can affect what they were talking about just previously, the retirement benefits. It makes a complication for processing for the contribution limits for retirement. So the way in which we've historically done it kind of works best with coordinating with retirement, but my bias tends to say I'm uncomfortable with trying to do this estimate, because then the pastor, if there's a big difference in that last month or so, they're going to have to make an adjustment, when they do their tax return, and that typically is going to raise a bit of a flag. I know it boxes you into a very short timeline to wait until year-end figures are available, but to me it just makes a little more sense from an accuracy standpoint, and less likely to create problems and mistakes later on, I think. So that more or less answered the question. No preferred way, really. Any other questions? I have a question for you. Does anyone recognize that church? It's within the Columbia Union somewhere. It's not an Adventist church, but it's somewhere within it, and it's a historic church. Just a matter of trivia here. Anyone recognize it? Anyone from West Virginia? It's fairly close here. That's the St. Peter's Catholic Church in Harper's Ferry, the one that sits way up on the hill if you visited Harper's Ferry. Anyway, just testing to see your geographic knowledge here. Anyway, okay, the topic here is political speech by churches and other tax-exempt organizations. We've talked about this in the past. There's a rule about prohibiting political speech by most 501c3 organizations. There's been a lot of clamoring to do away with it, to change it. So, is it time to change? Or is it time to just hold firm and stay with the rule and forget about it? In particular, I want to focus on a proposal to change this put forward by a Commission on Accountability and Policy for Religious Organizations that was sponsored by and organized by the Evangelical Council for Financial Accountability. I even have to look at it and read it, even though I was a part of that commission. ECFA was approached by Senator Grassley to address a number of issues a few years back, and to come up with some proposals and some solutions or recommendations based on a series of hearings that Senator Grassley had put forward, to focusing on what were perceived to be problems, particularly in the religious nonprofit community. They were focusing on some of the notorious televangelists that perhaps were stretching the rules a bit far beyond what they should be. And so they were investigating that. And they approached ECFA to see if they could come up with some recommendations, and they formed this commission. I was on one of the advisory panels. There were approximately 80 representatives of nonprofit organizations and churches and other religious organizations, as well as professionals in the nonprofit sector, lawyers and accountants, that were a part of this. I was on the panel of representatives of religious organizations representing the Seventh-day Adventist Church. And so we went through a process of considering and debating and discussing a variety of scenarios on as it pertained to these various issues that that Senator Grassley had raised. Now, he raised, I think it was about 16 or 17 specific questions. This what now we're talking about is just one of those. Okay, the basic rule for the prohibition from political activity is as you see it here, that any 501c3 organization is prohibited from engaging in and participating in or intervening in any campaign for or against a declared candidate for political office, for public office. Sounds fairly simple and straightforward. Covers all churches, most all tax-exempt organizations, which means that if we want to show our support for a candidate, you can't do it. You can act personally as an individual citizen and participate and contribute to a campaign of your favorite candidate or speak out against the one you don't like. But as an official capacity of anybody working for a church, no, you cannot. And nonprofit organizations and churches cannot spend money in support of or in opposition to a political candidate. There's some rather severe consequences that can result. A little history. We got this prohibition thanks to a floor amendment on the House floor by then Representative Lyndon Johnson in 1954. I believe that was when he was still in the House of Representatives. And a floor amendment is basically legislation that is already pending before the Congress. Someone makes amendment from the floor, as you've seen happen in many meetings. It can kind of throw the agenda for a curve, as we know, when someone decides to make an amendment that totally changes direction of the action on the floor. The interesting part of this had virtually no debate and was passed as an amendment to the Internal Revenue Code that was under significant revision in 1954. You might ask, why did Lyndon Johnson do that? Political reasons. The story, as I understand it, was that he was in a hotly contested election fight, and his opponent was endorsed by a leading nonprofit in the home district. He was mad about it and said, I don't like that. They have no business interfering with my political campaign. And so he proposed this amendment and basically outlawed that practice from henceforward. And it's stood since 1954 with only modest revision. There are many enforcement issues that are of concern. Number one, that rule raises a whole variety of issues of vagueness, confusion. The rules, as the saying goes, the devil is in the details. This is a good example of that. There are numerous attempts for guidance at this, on this rule to determine just what can and cannot be done, where the line is drawn. And unfortunately, it's created a lot of difficulty in terms of the Internal Revenue Service's attempts to enforce it. Also, what's the penalty for violating it? There are some significant excise taxes potentially, but worse still, potentially loss of exempt status for the organization that violates this rule. That is, as some of us have said, is like swatting flies with a howitzer. It's pretty much overkill. It doesn't correct the problem. It certainly doesn't do anything but just create havoc for the organization. And the focus of what I want to talk to you about today is the serious constitutional questions. We had the constitutional question still kind of percolating out there for parsonage exclusion. What about for this political activity? This has become a real serious issue of debate in the nonprofit community and particularly the religious community. both under free speech and freedom of religion. Kind of free speech is basically you can't tell me what to say, and you can't tell me I can't say it. I have the right to speak up. And in the context of ministry and the church activities, churches typically feel a moral obligation, ministers feel a moral obligation to speak out on issues of concern in society today. And if a candidate is vigorously trying to mess that up or create issues of moral concern, abortion is a key example. Churches have been very active in that. They can maintain activity in opposing abortion, but it makes it very difficult for them to speak out against someone who is either for or against abortion. So it muzzles ministers. That's kind of the focus of the issue that the commission was looking at. And the reality is there's a long-standing historic fact in our country where churches are the center of social and political activity, particularly in the African American community. This has been the focal point where the organization has been held for any of the, in the civil rights movement. This was a very key element in the civil rights movement, the organization of the churches in that era. But it still holds today. And there are other communities where this is, the center of the community is the church. Now, the other aspect of it is from the Internal Revenue Service's standpoint. Enforcement is very sporadic, it's uneven, almost non-existent in some people's view. I've been involved in a number of initiatives, some at the request of the IRS, some initiated by practitioners in the nonprofit community, to engage the IRS in dialogue about the enforcement issues on this particular rule. I know for a fact that the IRS hates to have to be the bad guy and enforce this, because it doesn't serve their purpose to raise revenue. It's a drain on the resources, and every time they go after someone, the last word there, it's controversial. It stirs up a hornet's nest. And so as a consequence, the law tends to be violated with impunity. And when the IRS does attempt to enforce the rule against, say, a church, often the response will be, well, how come us? You didn't do it to them, and them. And so it's a real problem. Okay, over the years there have been efforts to change the rule. I don't know how many, but there have been quite a number of attempts to either repeal or amend the rule in a way that would more or less neutralize it. More recently, since 2008, there's been a movement that's been coordinated by the Alliance Defending Freedom organization called Pulpit Freedom Sunday, where they organize and encourage and assist ministers on a given Sunday during the political season, a national political season, to stand up in the pulpit and defy the rule and come out and endorse a candidate or speak aggressively against a candidate, hoping to invite a challenge, baiting the IRS to say, come and get us. So, interesting enough, the IRS has not taken the bait. And there have been literally hundreds and hundreds of churches, and by some estimates, maybe even in the thousands of churches that have actually participated to one degree or another in this. So far, we haven't seen the IRS actually do anything about it. There have been some technical issues that give the IRS an excuse, but I think they just aren't really inclined to go after it and take that bait. More recently, there's in a perhaps more rational attempt to fix the rule. There's been a group of lawyers that I'm acquainted with that have started the Bright Lines Project to, as it says, create a bright line that's easy to determine so that people aren't trying to guess whether they've crossed that line or not. You know where the line is, you're less likely to violate it inadvertently. The Commission on Accountability and Policy for Religious Organizations came up with a proposal. And as I mentioned before, it was organized by ECFA in response to Senator Grassley. And the part one of the report, which this was part one of our report. And part two, which addressed only the political question, is this report. This addressed 16 questions, this addressed one question. So you can tell which was the hot topic that we had to consider. Notice the years in which we released the report. 2012 was the main report with all the miscellaneous issues involving parsonage exclusion and reporting requirements on 990s and so on. 2013, what happened in 2012? You want to remember? There was kind of a significant election that happened. National election for president, and Congress, and a variety. It was a big election year for 2012. It really was no accident that we split it in two and said let's wait until after the election and deal with the political question afterwards and deal with it by itself because it was the most significant of the issues. The first part, there was not a lot of shocking recommendations that came out of that. Most of it was hold steady, don't change anything, and kind of a gentle nudge to the IRS. Enforce the rules that are there, and I think you'll solve a lot of the problems. And that's kind of if I can summarize the 16 issues that were covered in the first part, that's probably about it. Nothing terribly shocking or grand in that. But in part two, they actually came out with something, a fairly strong recommendation to make a change to the rule. Those are what I just showed you. The Commission recommendations on this were that members of the clergy should be able to say whatever they believe is appropriate in the context of their religious services without fear of IRS reprisal, even if it relates to a political candidate. And that it should be permissible as long as they don't spend their charitable contribution dollars on that it doesn't cost them any more to do it. Talk is cheap, as the saying goes, so that a preacher can stand up and give the sermon and proclaim that he's opposed to the evils of so-and-so and we shouldn't vote for him. It's not going to cost anything extra. Okay. If you're already publishing something and you add another commentary about in the editorial section of the paper that you might produce, it's not going to cost anything. So it's really what it comes down to is it's an expenditure test, really. Because then we're not having to look at the content of what the person might have said and whether or not, because one of the cases that came up a few years back involved a minister that got up. It was during the campaign between George W. Bush and whoever the Democrat was. And no, it was the next one. Yeah, it was Kerry. That's right, it was Kerry. Because it centered around the issue of the war in Iraq and Afghanistan. And the minister in a fairly prominent church in Southern California gave a sermon. It was an anti-war sermon. So he didn't have necessarily the most flattering words to say about George W. Bush in the midst of a war. But he also didn't have a lot of complimentary things to say about, our now Secretary of State, because he had voted in favor of it. And so he said, kind of there weren't necessarily a lot of good things to say about either of them, but it was primarily an anti-war. But obviously, from the Bush campaign standpoint, it sounded like he was really hammering Bush a lot more because it was about the war in Iraq and Afghanistan. And so the IRS was obliged to investigate. The long story short, nothing happened of it, not surprisingly. But in any event, it caused a lot of stir because it required some degree of interpretation of what the guy was talking about to know whether or not he was actually violating that rule. So, but with this recommendation that's being put forward by ECFA through the commission, arguably could open the door and allow for some relaxed freedom to speak your mind, which I think a lot of people would feel much more comfortable with. Basically, the same rule would apply to other 501c3 organizations, that as long as it's related to their exempt purpose, they can speak out as long as following the same rule, kind of the expenditure rule. And basically it helps preserve the current rule that a tax-exempt organization can't use its funds and resources to contribute to or oppose a political candidate, and that rule would stand firm. So again, like I said, it's an expenditure test. All right. Any thoughts on that? Does it sound like a good proposal? Do you think it would be a good compromise, or do you think it would just create more problems? Anyone have any thoughts on it?
Historically, was not the discussion based on the separation of church and state? The church wouldn't be engaged in determining how the state would function. The state wouldn't determine how the church would function. That's why the tax picture comes across like it does with tax exemptions for churches.
Yeah.
And so therefore, since the churches are not being taxed, why should they start to try to manipulate and direct and politicize their world in
Right.
terms of running the government?
And that certainly was, I believe, what the founding fathers were looking at in terms of government needs to stay out of the business as a church, and the church needs to stay out of the business of government. That wall of separation between them, separating them. That's a very good point. That kind of goes against the idea of, the rule itself seems to be consistent with that idea. Then you're balancing it against, muzzling, the freedom of speech issue. And surprisingly, right, in current Supreme Court constitutional law decisions on the First Amendment, some are perceiving that the most sacrosanct of those rules is the free speech rule. There's a lot of kind of mush and pull and push and confusion with regard to the religion clauses. But the freedom of speech pretty much is pretty ironclad. And in fact, practitioners have realized, constitutional lawyers have realized, that if you can link a freedom of religion claim with the free speech, you have a far better chance of getting it upheld as unconstitutional, or depending on which side you're on. There's a lot more strength in it if you follow you emphasize the free speech side of it. But that's a very valid point. And on a personal level, on a personal level, I sort of lean that direction. It's like, I rather like my church to stay out of politics because it's divisive, it's nasty, and it's unpleasant. If people want to play on their own dime, on their own time, fine. But in church, that part of our mission, really. David.
Can you comment just briefly on, issues of enforceability aside, as you were talking about the IRS not coming after churches, but the difference between political statements from the pulpit versus lobbying we might do on a particular legislative issue, even like the activities you've been involved with this group. You know,
Right.
where's that line get drawn?
Right, and that's a very good question, because the prohibition is absolute, as it currently stands, against political activity. Don't at all, don't get engaged. However, lobbying, grassroots campaigns on the issues, focusing on the issues, even in an election season. So if there's a ballot initiative, there isn't a prohibition there. There is a restriction that says that a 501c3 organization and churches, as long as it's not more than an insubstantial amount of, it's kind of a vague, fuzzy rule in terms of where that line is drawn, but basically are allowed to do some lobbying as long as it's not more than an insubstantial amount of your expenditure of your resources and so on. Otherwise, there are some other rules that'll kick in and so on. But basically, you're permitted to do lobbying. So that's where there's a distinction there. It's, as long as it's focused on a candidate and it's focused on issues, or if you're lobbying Congress for a change of the law, or things like that, you're okay. All right. Any other questions or comments on this topic? I think we're kind of on schedule for what I think my timeline is. I think it is an interesting academic discussion for us lawyers to get engaged in. This, the reality, I believe, is that the likelihood of any change is unfortunately fairly remote. As I mentioned previously, there have been a number of attempts to change this law already, unsuccessful. They've seldom gained much traction, and in the current political climate, I'm not at all optimistic that anything will happen and that anyone's paying attention to this particular recommendation or the Bright Line test, or Bright Line project that I mentioned also. Yeah, you know the problem. We see it too much. And so not much of real substance will be done in the foreseeable future. But at least this is in the background there if ever there is a chance to change it. So, all right. I think we're ready for the next run. There we go. Shifting gears. I like to tie things together. You may look at this topic and say, what does this have to do with the previous topic? Not real close, but we'll figure out something. I like to tie things that have a nice segue into things. But we'll have to wait till the end. There's a point at the end that if you'll keep in mind what we just talked about, some of the issues that the commission was involved in, it sort of will tie in at the end. Anyway, as I mentioned, one of the concerns that the Office of General Counsel has is the issue of corporate compliance as a general rule, where there are more and more corporations that are being formed by church entities, and the ability of them to comply with the very specific rules that apply to corporations. There are a number of issues, for example, about there's reporting requirements to the state. Once you have a corporation, you have to file, you have to keep specific records to meet regularly, maintain your records of this corporate existence, as well as have an actual existing and functioning board of directors, and follow the corporate rules. So what I wanted to focus on today is, and the question that's posed as a title here, is sometimes I've heard it. I've been involved in a number of different boards, and the new member, newly appointed on a board or elected to a board, one of the first things they begin to wonder about, okay, now what do I do? What am I supposed to do now that I'm on this board of this organization or corporation? Now, even though this is kind of set with a backdrop of corporate rules and responsibilities of board members, this has broad application. it's not just for corporations. The principles involved here have application school boards, church boards, executive committees for conferences and the union. Kind of the same rules apply. So when someone new comes onto your executive committee or the board, school board, or the church board, it's important that they have in sight and in mind what it is they're supposed to do now that they're on the board. So that's kind of the focus of attention on this. And I have to give credit where credit is due. This is nothing original. It's not something I dragged out of thin air and my fevered imagination. So I borrowed heavily from this book. In fact, I've got a copy of it here. Handy little book put out by, as you can see down the bottom line, Board Source. They have a series of books like this. Very simple, easy to read. I bet you could sit down and go through this in an hour easily without having to break a sweat. This little book is 10 basic responsibilities of nonprofit boards. And so that's what I'm basing this presentation on, that I put together this PowerPoint. Okay, the first thing, the responsibility of a board member is to determine mission and purpose. Now you think that's pretty basic. Well, it's surprising how many people get on a board and come to the board with some new agenda. And they want to take the organization in a whole new direction. Okay, it's important that the board as a whole stay focused on what the purpose and mission of the organization is. It speaks to the organization's distinctive goals and its reason for existence. You know, what's the mission of the Seventh-day Adventist Church? Come on, you're all good members of the church. What is the mission of the Seventh-day Adventist Church? Preach the gospel. Very good. You know, follow the gospel commission. I think we can all agree on that. That is our mission. That is our purpose. That should show up in our mission statement. And that should guide the executive committee, the officers, and everybody else from that point forward, because that's part of the mission statement. It should set priorities. It should guide, and the board should stay focused on that. And needs to be reviewed periodically. I don't know that we would necessarily want to revise that one. We have other issues too that we could add to the mission. But it needs to be revisited on a regular basis. Let me back up here. On this point, an organization that I'm associated with has, as a part of its mission statement, it has a tagline. Just like that, preach the gospel. No one's going to forget that. Straightforward. This organization's tagline is, and if I say it, some of you may actually recognize it, it's an organization in the area, we touch people's lives. So, everything that organization does is somehow going to relate to our purpose for being is to touch people's lives. Okay. Every time the board meets, we spend the first 15, 20 minutes or so of the board meeting focusing on that mission statement, stories of lives touched. The board's mind now is focused. This is our mission. We touch people's lives. Once a year. It's great. I love this. Once a year, the president of the organization goes around and talks to each and every employee, 500 or 600 employees. Talks to each one of them, comes up to them and says, what's our mission statement? And if they answer correctly, they usually get some little prize, gift card or something like that. Out of 500 or 600 employees, remembering that tagline, we touch people's lives, and then they may be asked to give an example of that. Tell me a story of how that you carried that out or someone that you observed carrying that out. So we accumulate the stories of touching people's lives. What percentage of employees out of 500 or 600 employees would you guess can remember that tagline? Pardon? How many? 5%? Anybody want to hazard another guess? 95%. You're still low. But you're getting very close. It varies from year to year, somewhere between 98 and 99%. Why? Because the organization is driven. They are driven to emphasize mission, and everybody buys in, all the way from the chairman of the board to the person sweeping the floor. You know, everybody knows that they are touching people's lives, even the person, you know, manning that mop. They are touching people's lives. So that's an important thing. So I give you that as just an example of how an organization can be focused on their mission and how that's, you know, job number one for the board members, to stay focused on that. The second responsibility of board members is more mundane, but it's not really. This is really an important one too. It's one of the key decisions, because who sets the tone? As I mentioned, the president of the organization is so bought into the mission of that organization that he goes out and takes the time, and it takes a lot of time. Several days, you know, of steady effort, just focus in, just talking to each and every employee, all 500 or 600 employees, to make sure that everybody understands what the mission of the organization is. It determines the effectiveness and the direction of the organization. We know that. We know that a choice of a senior pastor in a church is going to change or continue the direction of that church. Conferences, the same way. Schools, the principal sets a new tone and the effectiveness of carrying out the mission of that school. And the board has that key responsibility of making that selection with these, you know, the mission of the organization in mind. And you need to identify the necessary skills and attributes. But true leadership is more than the sum of simple list of skill sets. You can get the person with the best degree and, you know, all the people skills that they have, but they can lose sight of what they're supposed to be doing. And here's a factor too, that the role of the CEO and the board's effectiveness are intimately linked. They have to work hand in glove, hand in hand. And here's a factor that I cannot emphasize enough. Expectations. Conflicts become readily apparent on any organization, on any board or executive committee, when the leader doesn't have a clear understanding of what the expectations are of him or her. You have to be very clear about it. So the board needs to set that. This is what we expect of you to, in your new role as the CEO. And this is something that's often overlooked, succession planning. You know, we have, in the church, we have pretty much a system involved and fairly regularized in terms of, you know, conference presidents and so on. But a lot of times in organizations, particularly where you have someone in place for a long time, you kind of get lulled into a false sense of security, and you don't necessarily know, you know, what you're going to do if that person dies, moves on, something happens to them, they're critically ill. What do you do? The succession planning is very important. And one of the keys to that is growing your leadership from within. We all know that. This is a fundamental aspect of, you kind of grow your team so that you know that you have someone coming up in the ranks who can fill the shoes of the, you know, the stellar leader. You know, mentoring issues, always good. Okay, connected to this, of course, is the third responsibility of a board is to support and evaluate the chief executive. Open communication, it's very important, between the board. Board doesn't, if there is not open communication, distrust builds, suspicion builds, and you feel like you're working cross purposes. It's not a good environment. So that requires frequent feedback, open lines of communication. I love this, no surprises. Again, the organization that I mentioned earlier, the board, the conversation between the board chair and the president. The president says, I got something to tell you. I wanted you to hear it first. So something wrong happening, the communication has to be open so that, that there are no surprises to the board. You don't come to the board meeting and find out, oops. You want to be informed of that with no surprises. And that relationship between the board chair and the CEO is very important, that they be on the same page, that they be working in tandem, because the board chair is the link between administration and the rest of the board. This is an interesting thing. How many of you do performance evaluations of your president? Good. If you flip that around, how many of you are subject to a performance evaluation? It's a higher percentage. Frequently neglected is, performance reviews of the president by the board itself. It's, they get forgotten.
In our case, it doesn't happen at the board level. They may do it internally, but as we approach conference, constituency meetings, we do conduct one from this office for all of our entities.
Yeah.
An evaluation that the nominating committee gets to see.
Yeah.
And we've also requested one from the North American division for us as officers here. We're approaching the session, or we just had one done midterm.
Yeah.
Which we did a 360
Yeah.
in this very room.
Yeah. I applaud that. I mean, it's I don't know that it's widespread.
No, it's not.
And, just by the show of hands, I assume it's not, and then also widespread across the division. It's kind of an informal evaluation. That's why presidents get nervous at constituency meetings, because no one's given the necessary feedback to say, you're doing a great job and here's why. And we think, and that weighs into the whole process, whether the person should stay on or move on. And I think it's something that needs to be more widespread. So
Does that happen at your conference?
in 30 years of being there, I think there's only been once that I recall where there was once or twice where there was a kind of a system-wide attempt to evaluate even departmental and officers and different functions within the general conference. And that was, like you said, is a sort of a 360 environment, where the questionnaire is sent out to the field and so on, about each department and so on. But that happens so rarely, and it needs to be happening more often. Okay, we'll just kind of skip past that. That really doesn't have a lot of relevance to us. It has to do with reasonable compensation and so on. The fourth area of responsibility, ensure effective planning. And this goes back to mission and purpose. That keeps its eye on the big picture, that mission and purpose, and that there are the goals and objectives and the resources of the organization are all pointed toward that. Kind of think in terms of the board, executive committees and boards as being at the 10,000-foot level, where you have a broad overview of things, the big broad picture, the big picture on that. The board is responsible to insist that comprehensive planning occurs, to participate in strategic planning, and assess the merits of the process and its results. And approve them, take action on them to say this is what we're going to do, and basically set it as a directive. And then you use that as a guide for budgeting. I mean, this is familiar territory, as a function, but it's the board's responsibility to make sure that actually happens. And then to follow up and track to make sure that it actually happens. And this is kind of the fleshing out of that last point on the previous slide. So that you have a system in place to monitor, all your programs and services and activities of the organization. To know what the organization actually does, how well it does it, should be, I like this choice of word in it, I borrowed it from the book obviously, should be at the heart of the board curiosity. Keep that word in mind, curiosity. The board is responsible to assess, those services. Ask questions. Curious people ask questions. Bored people on boards don't ask questions. They, nod off and raise their hand when asked to. But asking questions, is an important function of a board. I like to see that. Sometimes, presidents and board chairs get a little nervous when there's a long lineup of people at the microphone wanting to ask questions. But that is a barometer. It tells you, that the people are engaged and actually wanting to focus on what the organization is doing. And you need to know what data and information is necessary to measure your performance of the organization. That's board responsibility. And really, how do we know that we're making a difference? How do we measure that? You need to have things in place to know how to measure that. 6, ensure adequate financial resources. This is familiar territory here. Don't think this comes as any shock and surprise to anybody in this room. I would hope not. Just making sure the organization has enough money to carry out its purposes. That's a board responsibility, to see to it that there is that you have ways of achieving through your finances the goals and objectives of the organization by whatever it takes, fundraising, services that you charge for, whatever the case is for the particular organization. And needing to have the contingency plan to know what happens if it kind of falls below. What are you going to do? A good example, a school. You set goals, you're going to have an enrollment at a certain level. And so you make your budget accordingly. What if enrollment falls below? What are we going to do? What's our contingency plan? Where do we cut? That's the unfortunate reality of it. Or where do we figure out a way to find another revenue source? So resource development, board responsibility. The 7th responsibility in our list of 10 related to the others, to protect those assets and to have financial oversight, and that comes into play. There we go. In exercising our fiduciary responsibilities. That's a technical term that we all probably should be familiar with. And it's basically safeguarding the assets and resources of the organization, monitoring them on a regular basis, with quarterly reports and budget statements and all that exciting stuff that the rest of your administration kind of gets bored with. Cash investment oversight, all these, make sure you have adequate reserves and for contingency planning and all this. Risk management is an important aspect of this. The board should have input and oversight on that. And monitoring the chief financial officer. The board should be looking to make sure that the treasurer, the CFO, is doing the work that is necessary. And one very important of this, we all know, is the audit and finance committees. It's not a substitute. It's not something you put off to that committee and let them do their work and not worry about it. Their job is to do the number crunching, the hard work, and come back and make a report to the full board, which has the full responsibility. So it's just a matter of division of labor, really. And it's important, obviously, for people on committees like that to have financial experience. This goes back to the prudent, the fiduciary responsibilities kind of relates to what fiduciary responsibility means. It's basically a prudent person rule, that a reasonably intelligent person that's prudent in similar circumstances, what would they do? And that's kind of the standard that you work by. Audit committees and oversight, all this stuff, you're all very familiar with. And choosing and selecting the auditors, most everybody in this room doesn't have that choice. Sorry. But normally, in an organization, that would be a key consideration for the finance/audit committee of the board to determine who's going to do the audit. You hire and retain an outside CPA firm to do that audit, and you monitor their performance and their activity and so on. And if the organization has a Form 990, it's important. And surprisingly, how few board members of nonprofit organizations that do file a 990 actually read it or just even glance at it. You know, it's rare. Okay, building a competent board, that is a board responsibility. It kind of sounds sort of self-serving in a little way, in a bit. But it's important that the board understand and make a definition of what it needs on the board to effectively carry out its responsibilities. Sometimes that may be having a range of professionals that would relate to a hospital board, for example. You would expect them to have medical people on the board. But a hospital board with all doctors would not necessarily be a good thing. They would be focused on medical care and perhaps not the business that making those hard decisions. And this series of books that that the first one that this presentation is based on is key in this bullet point. When you have new members on the board and your executive committee, have an orientation. Don't expect them to just by osmosis learn how to be an effective board member. Tell them what they're supposed to do. Give them resources, give them information, training on what the board responsibilities are. And back again to the same topic, the board needs to be subject to, performance reviews too. There are varying ways that could be done. Having some outside resource applied to it to evaluate the board and its board's performance, consulting with them. There can be a self-evaluation process. There can be feedback from the administration of the organization. Here's an interesting question. Term limits. You hear that bandied around sometimes in the political arena and even in the church arena. How long should a president be president? Should we limit to so many terms? The pros and cons. Turnover brings in fresh new ideas and new energy, new connections. But on the flip side, you lose stuff too. The lack of continuity, you lose the historic memory of the organization when you turn over your board too frequently, and the organization changes as a result. It doesn't stay in a stable course. So, I don't know. Who thinks term limits would be a good thing? I don't think most people would. Nobody? I personally don't like them because I think I tend to fall into the latter category of seeing that as you lose the quality people. And from my own experience, if you have someone that needs to leave the board, that is the responsibility of the board chair to address that issue directly with that person. You know, the little heart-to-heart chat, saying we think the fact that you only showed up to the last 2 board meetings in the last period of time suggests you're not really with us anymore. So maybe it's time to move on. Or the person who's, you know, there are a variety of reasons. They're not engaged, they're negative. They're kind of producing a negative influence on the board that is kind of dragging the organization in an ugly direction. The board chair has a responsibility, in my view, to have that difficult conversation. That's how you address the term limits. They should be self-limiting in some way. So that's where I would tend to follow. It's harder to do. It's an easy, convenient thing to say, well, your term's up, sorry, bye. Just don't clap too loud, please. You know. Ensuring legal and ethical integrity. Effective boards take these 3 watchwords seriously. Compliance means do things right. So you follow all the rules. You do things the way you're supposed to do. The auditors don't have to write you up because you're doing things right. Transparency, it's about trust. If we're transparent, you know, people have more reason to trust us. When there's the perception that we're hiding something, you know, that doesn't serve anybody's purpose. And accountability, kind of related to the first one, do the right thing. This is the ethical responsibility, having appropriate conflicts of interest, checks and balances built in, whistleblower policies, and maintaining your records and all that good stuff. Those are the things that the board needs to take seriously and make sure the organization is actually doing. And the final item for board responsibility is enhancing the public standing. It's a communications and PR. Board members should be ambassadors for their organization. They should be out there promoting it. They should be proud of it and be out there selling the organization to the community that they serve. But it's a two-way street. You know, the communication link is two-way. The board members are also the eyes and ears of the organization out in the community, understanding what the community is saying about them and the feedback from that angle. That's where the board members, in the church context, you know, the lay members on your executive committee, they give you the feedback from the people that are members of the churches on what is important, how effectively the conference or the union is doing in fulfilling its mission. An interesting little tidbit here in facing the media. It's not a frequent thing that we have to worry about, but when we do, it's important. Speaking with one voice means one voice should be speaking. So, sort of intuitive there. You know, it's to avoid, you know, confusing mixed signals and so on, and that you consciously designate the spokesperson for the organization so that you have a consistent single message point going out when there's a need to communicate with the media. Because if the Columbia Union had 3 different communication directors that worked independently, that would be fun, wouldn't it? I don't think it would work. It's fairly common sense stuff. All of this is fairly common sense stuff, but it's important. I think it's important to reemphasize it, and the role and function of board members is important for a bigger reason. You know, it's really, it is my hope and objective in having put together this PowerPoint based on this book that it helps to put before individuals the importance of following the rules and doing things in an organized and systematic way and in running the organization so that we don't have more burdensome regulations imposed on us by higher organizations or by the government. And that kind of brings us full circle, really, to what I was talking about earlier. Senator Grassley that spawned this discussion about political activity and those other issues. Why? Because there was a perception that there were a number of religious organizations that were flaunting the rules and not following the rules that they were supposed to follow. So, Senator Grassley said, we got to do something about this. Fortunately, it's only gotten as far as an investigation. In the for-profit community, many of you maybe have heard of the Sarbanes-Oxley Act. What spawned that? Enron and a few other major scandals in business of that sort. So that rules governing corporations in the for-profit community were imposed on them because somebody screwed up really bad and thumbed their nose at the rules, didn't follow the rules. So it's my hope and expectation, as I said, that if we self-regulate and do our work successfully and correctly, that the government is not going to come and bear down on us and make new rules that will apply to all 501c3 organizations and possibly even churches. Kind of keeps that, as you said earlier, that wall of separation nicely in place, and I think it's important. So I think we need to avoid that hard lesson that the for-profit community did. That's just a list of the governance series that I referenced. All right. Any questions? Let's follow up on that. Yeah.
One of the best things that ever happened to me was when I first got into denominational work, I had a boss that took me to almost every executive committee meeting. I sat behind him and just listened in. I learned the other side of the organization by just listening to the executive committee, engaging management, what the issues were, and that really enhanced my understanding of the organization and helped me in my work. It was a huge blessing for me, and I'm not sure how many folks are doing that, but that's something I encourage people to do when you can. I know they cannot sit in executive sessions, but in the regular sessions, inviting your staff to sit in those meetings opens another window for them to experience the work of the church.
Well, it goes right to the heart of the mentoring, the succession planning, even that you're growing. Your leadership skills grew as a result. It's from within. I mean, you build your team, from the, those kind of opportunities are very valuable. And I think, excellent point. Any other questions or comments? All right, you've been a very quiet group today, uncharacteristically. Maybe I switched up the gears too much. But anyway, question back here.
A question about the first topic.
Yes.
Can you have a fundraiser, let's say an academy, has a fundraiser and invites the governor to come in and speak a week before the election? Now, he's not necessarily going to promote his candidacy. Now, it's the current, the current governor.
Mm-hmm. And he's running.
He's running for re-election, charging $60 a plate for alumni to come. The sponsorship does not go to the governor, it goes to the school.
Right.
Just wondering, what's your feeling on that?
That is one of those fuzzy lines that people labor over, and it's not a clear, I understand where the objective is. Well, he's not there for political purposes. He's there in his official capacity. And actually, in some of the interpretations of this rule, that hair, there is an attempt to try and split that hair. If the politician who's an incumbent is functioning in his official capacity, it's arguably okay, but 1 week before the election, no. My caution would be just don't go there. Because the reality is it's, even if you have the purest of motives and you keep those lines very clearly drawn, it's going to be misperceived, misunderstood, and people can spin it a different way. We had, a case in point, another conference in a far, far away place in America during the last election season. It was a local, I think it was a local election, may have been a mayoral race or something like that. And one of the local churches, the report that we got, and actually we got it through a news report, and this goes right to the heart of what I said about it's going to be misperceived. The report from the newspaper, and it was published online where we saw it, and it picked up on our news services, that XYZ Adventist Church hosts Democratic rally. That's what they said. That was the headline. And we thought, oh, that's just going way the wrong direction. It's so focused on just one side of the political campaign. And we contacted, the conference and the pastor and several others in leadership there and said, kind of what's happening here. What we were told was it wasn't a single party rally, that they had invited candidates from both sides, giving them equal opportunity to speak, and it was intended as a get out the vote, voter education opportunity for all sides to participate in. It may have been sort of lopsided because one side didn't show up, but certainly the news reporter that was there looked around the room and said, well, where's the Republican candidate? They're not here. And so he reports it, and IRS reads the newspaper. One of our churches could get called to task for that. But it's that perception. And then we're having to unwind that and defend them and all that sort of stuff. Fortunately, nothing seems to have happened as a result. I think, ultimately it was good in the end, but that's how the problems start. That's why in the overall discussion, I kind of think in terms of that, keeping that line of separation between church and state very firm. And I hate to see churches get too far down that field, because it turns the church into a political action committee rather than, what was that mission again? Preaching the gospel. That's the mission. See, this all kind of ties together. I knew I could do this. Tie it all together, even though two unrelated things.
There have been a couple questions texted in.
Okay.
The first one is, do you think it's wise to consolidate the corporation and conference and put the assets where the liability is?
That's a good question. We have, from time to time, advocated and it's largely driven not by so much the consolidation of under one entity as the concern that we have the primary risk liability of our conferences is in the unincorporated entity, which is the conference. That's where all your activities are. That's where all the finances are. All the risk-generating activities of running youth camps and all this are out of the unincorporated entity. So for risk, management issues, it's generally, the perception is we really need to probably incorporate to avoid the problem of what is often referred to as ascending liability. I prefer to call it vicarious liability because it doesn't just go one way, it goes every which way. But I would not take a hard line saying that it all ought to go under one single corporation at the conference level, because I know of several conferences around the division that have several corporations. They determined, and there's, on Vice of Council, that they needed to compartmentalize their risk groups so that the schools are under one corporation, the conference activities under another, the youth camp is under another, and so on. And the property generally is held by another. I think they have 4. You know, that takes a lot of management, and that goes back to my original comments. Formation of new corporations means you've got a lot of compliance issues to worry about, and you need to know what you're doing and get good counsel and resource and so on. But long story short, yes, sort of.
All right, there's one other one here. Are we any closer to obtaining a variance for the working hours of under 16 workers?
That I'm not familiar with. I'm not directly involved in that, so I don't have a good answer for that, quite honestly. So I can look into it. If whoever asked the question, if you want to corner me afterwards, and maybe I can find out who's involved in it and kind of get you to an answer person. All right. Any other questions? Looks like you're going to get a 5-minute extra in your break. All right. Thank you very much for your attention.